Welcome to Continental Divide, a guide to Colorado divorce.
Hello, everyone, and welcome to Continental Divide, a guide to Colorado divorce with Kristi Anderson-Wells of Wells Family Law in Denver, Colorado. A former executive compensation attorney and author of the Executive Compensation Handbook published by the American Bar Association, Kristi brings a unique perspective to divorce, complex finances, parenting, and problem solving in Colorado family law. My name's Sean O'Connor, and today we're talking about collaboration, litigation, mediation, and the different paths families can take through divorce in Colorado. And we've got a great guest, Anne Gushurst. Hello, Anne.
Hi, Sean. Thank you for having me.
Of course. Well, and Kristi, great to see you.
Good to see you too, Sean. So I want to take a minute before we get started to tell everybody what Anne brings to the table today, because Anne is truly one of the founders of collaborative divorce law in Colorado. She's also my former partner and a terrible instigator. But she was a tremendous litigator back in the day before she retired to working as a neutral. She does a lot of mediation. She does collaborative divorce facilitation. And she really was one of the people who, at the very founding of collaboration in Colorado, became instrumental in making this a way to practice. So not only does she speak to what is it like to litigate in Colorado, what does it mean to mediate in Colorado, but also really she's the expert on what it means to collaborate in Colorado.
Oh, I love it. That's a great...
Wow, that sounds...
Uh-oh, a lot to live up to, Anne.
What? Did I make you cry?
Well, you have in the past, but not today.
I also love the term she's a neutral. Like, is that just sort of casual jargon you guys use?
No, it's a term of art. A neutral, I mean, if you're a litigator, you're representing a party.
Right.
If you're a neutral, that means you're a mediator. You're not supposed to take either side.
Right.
And a neutral exists in collaborative law as well. We call them CDFs, collaborative divorce facilitators, and they really help people through the process of collaborative law. I mean, Anne, can you expand on that role?
Well, when we first started out in collaboration, it was just really two attorneys, and we quickly started using divorce coaches, but there weren't enough. And working in collaboration really was a paradigm shift. They told us that in the trainings, but until you start doing it, you don't really realize how much that is the case. And some of our divorce coaches who came from the mental health world thought that they would have no trouble being neutral, and it turned out that that was not the case.
Well, maybe we should talk about what the difference is between litigation, mediation, and collaboration.
Yeah, like some definition kind of thing.
Okay, well, let's start with litigation. If you've seen The War of the Roses or Kramer v. Kramer, you know what litigation is. So,
What divorce was it? Divorce Story was the Laura Dern one recently.
oh, the one with
Adam Driver,
not the big nose guy, Adam Driver, and Scarlett Johansson, wasn't it?
Yeah.
He's gorgeous.
All of those
movies. Called An
really
American
describe-
Family, wasn't it?
Yeah. No.
Yeah. And actually that is perhaps one of the best instances, because they started out with such great, intentions of being kind, and the divorce attorneys took them to different places, and it really was driven somewhat by the litigiousness of the divorce attorney, and at least on one side, if I remember correctly, and people are being
100%.
unreasonable, and this loving couple. And I think the underlying story idea was that she got a job on the other coast and she really wanted to take it, and so it wasn't even like a fault-based situation where somebody really had an axe to grind. It was really tragic, but it really, really mirrors a lot of the cases that we do. So
Right. It illustrates how divorce attorneys can take a case where two people have the best intentions about how they're not going to have a fight, and the divorce attorneys drive it to conflict.
Exactly.
Because litigated divorce is focused on a win-lose scenario. You go to court in front of a judge, one of you wins and one of you loses, and that's the entire focus.
And
And what is
I would
what
say
is the
it's
attorney
more than
like?
the attorneys, right? It's like the whole way the legal system is set up
I
is
was going to say it's
adversarial.
a system
It's a
issue.
real system. And if you look at where our laws evolved from, it was always adversarial, right? In
Right.
criminal law, it's you versus the state and two landowners, which is a lot of our property law has driven how our courts function right now. It's all about, me versus you, and it's a line where it goes. And that's an unfortunate model to have when you're talking about families because, you know, you have to have this person in your life forever. And if you say or do things that can't be walked back, it causes a lifetime of grief. Anyway,
100%.
and so
So how is collaborative different?
well, I mean, there's the one other thing I was going to say about litigation. This sort of segues into why collaboration is different is that people have expectations of what litigation looks like. We've all watched Law and Order. We've all watched, all Perry Mason. So we
My
know
cousin Vinny.
my cousin.
That's
It's
an
a
all-time
true.
favorite. Gotta watch that one.
Oh yeah, I could recite it literally. So we have this whole system that's built on adversity, and what collaboration says is like, this is not the way to resolve a family situation. And instead of only caring about what's good for you, you have to approach your divorce with the other person's interests on your radar screen. You
Yeah.
have to agree that I'm going to look for something that's the best for everybody. And that's a fundamental shift in perspective. And that's what collaboration attempts to do. Now, we are not always 100% successful. I mean, we usually get our cases done, although I had a couple of spectacular non misfires. But in general, it's a difference in what the people are expecting to do.
And it's not something they teach you in law school. I mean, it goes very much against all of the things we learn in law school as lawyers, how we're supposed to represent parties. So let's talk about the fundamental. How does it work in reality?
Yeah.
What happens differently in a collaborative case versus a litigated case?
Well, what I used to always tell my clients when I was representing people in these cases is that you don't get to hide behind me. You are going to be doing the heavy lifting. And, it's funny because I think if you talk to people who go through litigation and people who go through collaboration, they would in both instances, they would say it's the hardest thing they've ever done. But they do different things. And they don't have the perspective of how much better collaboration is for them in the long run because we have everything is done in a very open forum. So there's no letters going back and forth where people say mean things, get out the knives. It's done in 4-way or 6-way meetings.
In
So
person.
in person,
Everybody's at the table.
Yeah.
sometimes
So
on Zoom, but yes.
both parties, mom and dad, are there, and they each have their collaborative counsel there. And then a collaborative neutral is there who's guiding the process. Who else is at the table?
Well, usually I insist on financial neutrals. And sometimes we have child neutrals, child specialist neutrals. And generally child neutrals and financial neutrals do a lot of their work individually with both clients without the attorneys there. Just, because it's a more informal process and people are much more willing to be reasonable when they're given the chance to be reasonable.
Agreed. And then sometimes we have appraisers, but in the
Sure.
collaborative process, both sides are choosing their neutrals together. So instead of like in a litigated case, you have I might get a business valuation expert to
Right.
represent my client's interest in what the value of that business is going to be. And my husband might get a different expert, and they're dueling experts, both of them cost a fortune, believe me. And then those guys are going to testify in front of the judge about what the value is. And then the judge is going to weigh which expert is more credible or, what the value should be based on that testimony. In collaborative, both parties are saying, we agree on this expert.
Yeah.
And this is our joint expert, and we're going to move forward. I mean, if the expert does something that one of the parties doesn't like, they might choose another second opinion, but they're choosing their experts together, which is really important because there's a really very different take on what happens if a case falls out of collaborative. I mean, let's talk actually first about the timeline. When does the work of a collaborative case take place, Anne?
Well, typically we do it before somebody files a divorce case. And And there were two reasons. Initially, it was primarily because once you file with the court system, it drags you in,
Right.
and you have
You're on
some
the court's timeline.
plaintiff and a defendant, or a plaintiff and a respondent, and that puts them into adverse relationship with each other. And it was really important to do it before you filed when we first started, because court cases would not hold your case in advance. I had two of them. No, we're not doing that. And so they had to dismiss their petitions, which was
So when you're in a litigated case, you've got a deadline. I have to get my witness disclosures in 56 days before the hearing date. And that means my client's going to have to pay money for my expert witnesses to get all their work done before that date. And it does tend to amp up the conflict when you are working on this timeline that is not yours to drive.
Right.
And if a court won't cooperate with letting you pause to do this other process, you've kind of undermined this whole collaborative process. And I do agree with that. There have been a number of occasions in collaborative cases where people said, oh, let's just file it and we'll collaborate over here while the case is filed. But that tension of the court driving the case can create the kind of conflict that makes it much more like a litigated case and makes the collaborative process, I think, less successful.
Well, for one thing, they haul you in for a status conference, and the attorneys have an agreement with their clients that they can't represent them in court. So we have to send them without us. And I had one case where they went into the court facilitator, who was just treating them like they were hostile to each other. They were so offended. They came back convinced that everything had to be collaborative, and they dismissed the case. And they actually had tax reasons that they thought it would be advantageous for them to file. But I mean, it was just a crazy time, because I think it was 2009 or 2007. I can't remember. It was a long time ago. We got this ethics opinion in Colorado. It was the year I got elected to be in charge of the state organization, of course. And they got this ethics opinion, which is the only one in the US, and it's a real outlier, that said that collaborative law was unethical per se. So we've got all these people excited about doing it, and then all of a sudden, like, the bar, the ethics committee of the bar is saying, you can't do this. Like, so.
I mean, the good news is now we have a statute, the Uniform Collaborative Law Act, that makes it per se not unethical to practice in collaborative law. It's been recognized. There's outlines about how we have to do it. So that's no longer an issue. But I mean, going back conceptually to the structure of a collaborative law case, we've got these meetings, they're taking place with everybody around a table, and all of that work is usually being done before the case is even filed.
Yeah.
If you were in a litigated case, your case would be filed. It would be served on the other party. You'd have 42 days to get all your work done on your financial disclosures. And then you have a series of deadlines you have to meet. You have to have mediation by a certain date, and your witness disclosures and depositions have to fit in there. And you're doing discovery and gathering information, and you're all on the court's timeline. Whereas in the collaborative case, you're doing all your work before the case gets filed.
We used to talk about it as mountain climbing, that you're all linked together. And so you can only go as fast or as slow as the slowest person. And that was really important for people to understand at the beginning.
And when we talk about mediation exists in both worlds, right? So mediation exists in a litigated case. Virtually every pre-decree case in Colorado, a court will order mediation. That means if you're in a divorce, if you're in a legal separation, a court will say you have to mediate before you can come to my courtroom. Virtually every single case. If it's a post-decree, that is people coming back to fight later about stuff that, disagreements they've had since their decree entered, sometimes there are requirements in the settlement agreement about mediating before filing something, and some courts will not require mediation, but it's pretty rare. Wow. So mediation it's in virtually every litigated case in Colorado. That is my experience. And do you have a different experience?
No, 100% every case, even cases that shouldn't probably have to go to mediation.
Like if there's DV, you shouldn't have to mediate. If there's domestic violence, you shouldn't have to mediate. But what's interesting is
one size fits all.
Restriction hearing and a kid needs medical attention, you're going to run out and get a mediation first.
Right. If it's an emergency, crazy. But collaborative is like mediating in every meeting before the case is even filed. It is literally just a series of mediations about various topics that occur before the case is even filed. So when we talk about mediation, it exists in pretty much all of your divorce possibilities in Colorado. The most important thing about mediation is you should never go to mediation until you have all the information you need to get to know that you're getting
And
a
you
fair
should have
settlement.
talked about it, right? How many people come into mediation to me and they're like, "Oh, I hadn't thought about that." I'm like, "Well,
Right. Oh, I didn't even know we had that bank account. I don't know what the business is worth.
no, I mean,
Yeah.
and it's crazy because one of the things that can happen is you can have a lot of agreement on one side of the case where one person has a better case and the other side's like, "Oh, let's just settle this." Well, you know, if you're in a litigation, you're never, if you have a decent attorney, going to settle this because this gives you leverage over this.
Oh, I
And
just had that case. I literally multi-million dollar case. Husband's high earner between $50,000 and $70,000 a month. He doesn't want to pay maintenance on a 30-year marriage. So he basically wanted to settle the property with a promissory note that had such a high monthly debt service that he wouldn't have had enough net income left over to pay maintenance. If you go in front of a judge is going to say, sell property, equalize the estate, and then we do the maintenance on top of it. But he was really pushing to settle one part that would have really disadvantaged the wife in that case. So yeah, but interestingly, in a collaborative context, that issue would have been dealt with up front. It wouldn't have been like, I'm trying to trick you into settling the property on this case so that I don't have to pay maintenance. It would have been like, I really want to settle the property without, selling real estate because
my
I need that.
ability to run my business or
Right.
yeah. No,
But
it's
the collaborative team would have addressed his needs. It would have been part of the conversation instead of in the litigated context, it being, I'm going to try and see if I can get this part settled first so I can mess with your ability to get maintenance.
no, and I've seen that
Very different
sometimes.
concept.
We'll settle kid issues and then, out come the hatchets.
Yeah.
But anyway, so
Tell about the trap and collaborative. What happens if a collaborative case, if somebody wants to stop being collaborative and file their case and move forward?
Well, this is the trap that the Law Society was very, very, very upset about. If collaboration fails because somebody's being unkind, untruthful, devious, crappy, then both the
To use a technical term.
yeah, well,
That's
that's
a legal
another thing,
technical
but
term.
I'm back to my New Year's resolutions, at least for tonight. And then the attorneys have to withdraw. They're not allowed to prosecute the case. And technically, you're not allowed to use any of the work product that came out of the case. Now that
And none of the experts. You can't use the experts unless
both people agree in writing. And so that has never been an issue because I've had 2 cases fail.
You've had 2?
2. One
I
I
had
also
one
win.
case fall out of collaborative, and I think you were on that case.
Yes. Oh, okay.
If the parties
I don't
agreed.
count that one. That one doesn't count. That would be 3. But no, I had one where they called me as a witness, and I was so freaked out. I forgot. And yeah, if I told you who the examining and cross-examining attorneys were, you'd cry. Think about them.
You were the neutral? They can't call you if you're a neutral.
I was the attorney.
Oh, that's even worse.
Yes, I was the attorney of 2 people who should never have done collaborative law. And the other attorney didn't know what she was doing. So she stayed up all night before the second meeting, came in, no sleep, and was convinced that there was fraud in the tax return. She spent the whole entire night going over the tax returns. It was the worst. But anyway, I was so nervous that at the end of my testimony, I'm like, oh my God, I was supposed to ask the court if I'm being ordered to testify because of attorney-client privilege. And the court goes like, oh yes. But it was really good from one perspective. It's like, I've tried hundreds, maybe even 1,000 cases at that point, and I forgot the first most important thing. It was horrifying. It was horrifying.
So this is one of the reasons I think people are afraid of collaborative is this rule that if the case falls out of collaborative, so one person has lied, case falls out of collaborative. One person has hidden assets, case falls out of collaborative. One person says, I'm fed up with this process. I don't want to sit through any more team meetings. I'm filing my case. Case falls out of collaborative.
Right.
The thing that frightens people is, well, if my case falls out of collaborative, I've got to hire a new attorney, more expense, hire new experts, more expense, and it's going to be overwhelming. Well, first of all, out of the, I don't know, I've done probably over 100 cases now. I don't know how many Anne's done. Since she invented it, she's probably done 500. I don't know.
I stopped counting at 121.
But I've only lost one case out of collaborative. And the reason is, so because people are afraid of that added expense, they continue to sit at the table. And these meetings aren't necessarily easy. It's not like we sit around the table singing Kumbaya. We're dealing with very difficult issues at that table. Things like, what are we going to do about parenting? Dad has never had parenting time with the kids because he's been so busy earning the money. And
Or
dad is,
somebody's got a substance abuse issue. And
right, substance abuse. We've had
how do we
really
keep them
difficult issues.
Wow.
And so it's not easy to sit at that table. But part of what keeps people coming back is the fear that the case will fall out of collaborative and they're going to have to get new counsel and they're going to have to get new experts. That brings them back to the table. I'm not kidding. Anne, what is your take on it?
Oh, I agree. 100%.
You do? It also keeps counsel from...
We say to everybody, this feels like it's going to be easy because we're getting along. You like each other's attorneys, but do not kid yourself. There are going to be some times where people behave badly. We talk about this. There's all these agreements they have to make, and one of them is that they have to not interrupt and they can't call each other names. And
condescending tone is, I think, one of the rules. No condescending.
Right, well,
so let me interject. You've defined the various modalities, so to speak: collaboration, mediation, litigation. What cases are best for the collaboration approach? And are there cases that it's like, don't even try it? Have you seen anything?
Well, Anne and I might have a disagreement here.
I would say most cases can do collaborative, but there are some cases that shouldn't. So starting with the cases that can do collaboration, you have to have a general baseline of trust that if you tell me something, even if I think you're a lying skunk for having an affair with my sister, I still can trust that the statements you give me are true.
Yeah.
And, even for people who don't have trust, as long as they have the ability to check some of the facts, if they can put the other person's needs into play, like, I hate you for leaving me, but, our kids need you.
Yeah.
That person can do a collaborative case. Somebody who's a pathological liar, somebody who cannot cede decision-making to somebody else, somebody who can't make decisions at all, somebody who's so intimidated that they can't speak for themselves. Those are people who can't do collaborative law.
Agreed. So and this is where I think Anne and I disagree. If there's domestic violence in a case, that makes it really hard because you have to be able to have a client with enough spine to ask for the information they need to make an informed decision in their collaborative process. That said, I think Anne would agree with me that a lot of domestic violence victims do not do well in front of a judge or in court because of how they've been treated over time and how they present. And so in a case where there's DV or there's coercive control and there's manipulation around finances, if the entire collaborative team knows about it and we're open about it, about what we're dealing with, I think it can be successful.
You can navigate that.
It's just
It's
not
a lot more work. It's a lot more work.
Not open about it.
Yeah. I mean, DV victims often are so used to putting their needs last is one thing, but also dancing around subjects. So they come across as lacking credibility in court.
Yeah.
And it's because they're afraid to say A is A and B is B, because that could get them in trouble.
Yeah.
But collaboration can really protect them if you put enough support in for them. But if you have the kind of case where you expect a DV victim to stand up to somebody, then that's not going to work. So we have to have an agreement from the person that's the perpetrator. You got to let this person speak. You cannot cut them off. And we separate really frequently. So you have to be careful. But, litigating in those cases is also terrible.
The alternative isn't attractive. Well,
Agreed.
Ladies, we're out of time. And
Sorry.
I've enjoyed immensely all of this. Thank you so much. And thanks for joining.
Also, Sean, you're amazing too.
You know something, Kristi? You are amazing. You are the most amazing person I know. She was building a deck yesterday all day.
Oh my God. Well, we're gonna rename this episode the Love Fest, and I'm gonna sign us off. But great to see you both, and I hope to connect again soon.
Yeah.
Great seeing you, Sean. Bye, Anne.
Thank you for this opportunity. I really appreciate it.
That's it for today's episode of Continental Divide, a guide to Colorado divorce. If you'd like to learn more about Kristi Anderson Wells and the team at Wells Family Law, or if you want to connect with Ann Gushurst, you can do that by visiting the Wells Family Law Colorado.com website. And as always, thanks for listening. Don't forget, leave a review, maybe a thumbs up, subscribe, maybe share a link with someone in your world who is dealing with some complex family law matters. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.